Good morning, Sir Clemens and friends. Today we are going to present about Chapter 2, National Differences in Political, Economic, and Legal Systems. Our group consists of me, Ella, Falis Salim, Latifa Salsabila, and Ivan Borisman. Next slide. Here are what we're going to discuss. The first one, we're going to discuss about the introduction regarding the chapter, and then the political systems, economic system, legal system, and lastly, conclusion. Next slide, please. Introduction. So, international business can be much more complicated than domestic business. This is because different countries usually have different political, economic, and legal systems. They vary significantly in their level of economic development and future economic growth trajectory. All these differences can and do have major implications for the practice of national business. They also have a profound impact on the benefits, costs, and risks associated with doing business in different countries. Hence, in this chapter, we're going to learn more about to develop our awareness and appreciation for the significance of country differences in political systems, economic systems, legal systems, economic development, and societal culture. Uh, Here we will often use the term of political economy, which means the political, economy, and legal systems of a country that are interdependent. They will interact with and influence each other, and in doing so, they affect the level of economic well-being. Next slide, please. So, what if a country doesn't have a good political economy? Like, what could happen? Here are the illustration that I taken from the book and summarized it. Zimbabwe history. So, as we all know that now in today's days, Zimbabwe has almost the worst inflation rate. But other than a bad inflation rate, they also have a few other problems such as property rights have been violated, corruption has become endemic, private enterprise has been discouraged by regulations, taxes, and corruption, and more than 80% of the population is now unemployed, which the normal unemployed percentage rate usually stands from 4 until 5%, and Zimbabwe has 80% of the population unemployed, which is above the normal average. And lastly, they also have life expectancy that has declined. These all problem uh, could happen because when British gave Zimbabwe its freedom and leave the country with democratic institution, the Zimbabwe chose a man called Robert Mugabe as their leader that um, managed the country as a one-party state with limited political freedom, and that stands for 37 years. Sadly, Robert Mugabe didn't do what it takes to lead a country. He didn't do his responsibility and just wanted to go with what his group of people want. He just make himself richer while make the other of the Zimbabwe poorer. Next slide, please. So from the example that I mentioned before regarding the Zimbabwe history, we can conclude that a political system shapes its country economic and legal systems. A political system itself could be defined as the system of government in a nation. So it's basically how a government rule over a nation. Mm, Political systems can be assessed according to two dimensions. The first one is collectivism and individualism, and the second one is democracy and totalitarianism, which we will dive deeper in the next page. These two dimensions are interrelated. Systems that emphasize collectivism tend to lean toward totalitarianism, whereas those that place a high value on individualism tend to be more democratic. Next page, please. Uh, Next, we have collectivism. Here, collectivism refers to a political systems that stress the primacy of collective goals over individual goals. When collectivism is emphasized, the needs of society as a whole are generally viewed as being more important than individual freedoms. In such circumstance, an individual's right to do something may be restricted on the grounds that it turns counter to the good of society or to the common goods. According to an ancient Greek philosopher, it is argued that individual rights should be sacrificed for the good of the majority and that property should be owned in common. Counter-example that do collectivism as their main culture, such as Japan, Indonesia, and South Korea. Hence, in term when they try to make their own decision, they will goes with what will benefit the country the most instead of what will benefit the government the most or what will benefit a specific of group the most. Next slide, please. Next, we have individualism, which is the opposite of collectivism. Individualism itself refers to a philosophy that an individual should have freedom in his or her economic and political pursuits. In contrast to collectivism, individualism stresses that the interests of the individual should take precedence over the interests of the state. According to Aristotle, communal property receives little care, whereas property that is owned by an individual will receive the greatest care and therefore be the most productive. Another example that stands individualism the most as their culture is Australia and United States. Hence, from if we make a comparison between collectivism and individualism, we can conclude that if a government seek for a more prosperous life, then they will go with a collectivism. But if a country seek for more profit, for more gain, then they will they will do the individualism. Next slide, please. Next slide will be explained by Alice.
So the part for democracy. Democracy is a political system in which government is led by the people, exercised either directly through elected representatives. So there is two types of democracy. The first one is direct, and the second one is representative. So for the direct democracy, or you can say pure form democracy, it believes that citizens should be directly involved in making in decision making. So in the people decides on policies without any representative or any third parties, intermediaries, something like that. For example, the country is Switzerland and Italy. And then for the representative democracy, the people vote for elected officials who can represent their voice, their needs within the government. So, and because of the democracy doesn't have any third parties or any intermediaries, so they can be more transparent, but they're kind of like less efficient than the representative democracy. And because of the representative democracy have the third parties, they have the intermediaries, they can be more efficient, but then they kind of like less transparent. Next slide. Okay, for the totalitarianism, it's a system of government that is centralized and dictatorial, requires complete subservience to the state. Uh, it's the ideology of absolute power. So there are four major forms of totalitarianism. The first one is communist totalitarianism. The most widespread form. Communism is declined worldwide and have collapsed since 1989. 89. For example, like China, Vietnam, or North Korea. Next slide, please. Okay, and then the second one is theocratic totalitarianism. It's the political power is monopolized by a party, group, or individual that governs according to religious principles. The most common this form is based on religion of Islam. So the freedom of political and religious expression is limited on based on Islamic laws. For example, country like Iran also or Saudi Arabia, they kind of like have what is that political power based on the Islam laws. So and all the principles that like that is limited to that. Next slide, please. The third one is tribal totalitarianism. A political party that represents the interests of particular tribe monopolize power. This form has arisen time to time in African country, and it's not always the major tribe will be the one who monopolize the power. But for example, like in Kenya, politician from Kikuyu tribe long dominated the political system, and most country like Zimbabwe, Tanzania, Kenya, and any other African country use this kind of totalitarianism. Next slide, please. Okay, and then the last one is right-wing totalitarianism. It generally permits some individual economic freedom but restricts individual political freedom. Until the early 1980s, many of which were military dictatorship. For example, when it's Indonesia during our former president Suharto, and they kind of like wanna in this form they kind of like want to keep so the communism didn't rise to the people. Next slide, please. Okay. Then there is democracy for that's called pseudo democracies. It's they this form lies between pure democracies and complete totalitarian systems of government. So there is no, I think, and most of the countries uh, using this kind of like, oh, sorry. There is no there is other definition that said a political system which called itself democratic but offers no real choice for the citizens. For example, Indonesia during our former president Suharto era. So back then he was a president for 30 years for more than 30 years with no, and the people are kind of like forced to choose him because there is no other option other than him, right? So this is they also call it pseudo democracies as fake democracy. Okay, so yeah, it's the position where the people giving the option, but they said that, but they call themselves they're democratic. Next slide, please. Okay, for the economic system, there are two types of economic system. The first one is market economy. It's the so all productive activities are privately owned as opposed to being owned by the state. So So this means that the production with voluntary exchange or contracts and the prices rely on supply and demand. And but the downside of this, there will be monopolies. There will be some monopolies company. They will let the prices arise and take greater profit, and the customer will be get the bad side of it because all the prices will getting higher and getting really expensive. And then the contrary of it, there is common economy. It's where the government plans the goods and services that country produce. So the quantity in which they're produced and the prices at which they are sold. So government will uh, what do you call it? Will set the prices and then the production schedule. But the downside is the abolition of the private ownership means there is no incentive for individuals to look at the better ways to serve consumer needs, and then it will lack of the dynamism and innovation. For example, for this country is like China, Cuba, Laos, and Vietnam. Next slide, please. Okay.
Next is the mixed economy. So a mixed economy combines elements of both market and common economies, with some sectors controlled by private ownership and free markets, and others by state ownership and government planning. So I have three examples of mixed economy in Indonesia. The first one is subsidized housing. The government provides financial assistance for the purchase of first homes for people in need. In practice, the construction and sales of these houses are still carried out by private parties. This is an example of a collaborative effort between the government and the private sector in economic practice. The second example will be the support for SMEs or OMKM. In terms of business development, the government also provides significant support for small, micro, and medium-sized enterprises. For example, there is a cheap business credit available for SME owners in need of capital injection. Typically, this business credit is available in government-owned banks. And the third example for this will be BPJS Kesehatan. Another example can be seen in the healthcare aspect, as an essential part supporting the economy. People certainly need access to healthcare. Unfortunately, not all people can afford private insurance with varying premiums. Therefore, the government takes action and introduces the healthcare program, namely the Social Security Administrator BPJS for health. With this, there is equal access to healthcare so that the wheels of the economy can continue to turn. Next slide, please. The different legal system. So the legal system of a country encompasses the laws and processes that govern behavior, enforce laws, and provide redress for grievances. It plays a crucial role in international business by regulating business practices, transactions, and defining rights and obligations. Variations in legal systems among countries can impact the attractiveness of a country for investment or market opportunities. So the first type of the different legal system is common law. The common law system, originating in England and spread to many former British colonies like the US, relies on tradition, precedent, and custom for legal interpretation. This system grants judges flexibility to adapt laws to individual cases, with each new interpretation setting a precedent for future cases. This iterative process allows for the evolution and refinement of laws to address emerging situations. The example for this would be in Indonesia. Elements of common law can be observed in the legal system, particularly in interpretation and application of contract law. Courts may consider past decisions and legal principles established in previous cases to interpret and apply the law in contract disputes. This allows for flexibility and adaptability in addressing unique circumstances. Next slide, please. Now the second type is civil law. Civil law system relies on detailed legal codes and statutes for interpretation found in countries like Germany, France, Japan, and Russia. Unlike common law systems, civil law systems are less reliant on judicial interpretation or traditional and precedent, leading to a less adversarial process. Judges in civil law systems primarily apply existing laws rather than interpreting them, resulting in less flexibility compared to common law systems. The predominant legal system in Indonesia is the civil law, which is based on codified laws and statutes. Most aspects of law, including family law, property law, and criminal law, are governed by civil codes established by the government. For example, the Indonesian Civil Code regulates various aspects of civil relationships such as marriage, inheritance, and property ownership. Next slide. The last the last one is theoretical law. Islamic law based on religious teachings like the Quran and Sunnah governs moral behavior and extends to some commercial activities. In countries like Pakistan, it influences legal system such as prohibiting interest payments, leading to the rise of Islamic banking. Globally, Islamic financial institutions manage over $1 trillion in assets with a presence in Pakistan, Gulf states, Egypt, Malaysia, and Iran. While theoretical law may not have a direct parallel in Indonesia legal system, theoretical legal concepts are often studied and discussed within academic and legal circles. These concepts may include theories of justice, legal philosophy, and jurisprudence. Scholars and legal experts in Indonesia engage in theoretical discussions to analyze and critique legal principles, systems, and practices, contributing to development and refinement of the legal framework. Next slide. The differences in contract law. Common law and civil law systems differ in their approach to contract law. Common law contracts are detailed due to vague laws leading to adversarial disputes, while civil law contracts are shorter as many issues are covered in civil codes. International firms must understand these distinctions to avoid missteps. Some countries adopt the United Nations Convention on Contracts for the International Sales of Goods, or CISG for short, but not all have ratified it. Alternatively, firms may choose arbitration through courts like the International Court of Arbitration in Paris for dispute resolution. So in Indonesia, one example that illustrates the difference between common law and civil law system is in the approach to contract law. Under the common law system, contracts tends to be very detailed and comprehensive with all possible contingencies spelled out. This is because common law system rely heavily on judicial precedent and interpretation, leading to a need for explicit terms to anticipate potential disputes. On the other hand, in civil law systems like Indonesia, contracts are typically shorter and less specific. This is because many legal issues are already covered in civil code, reducing the need for exhaustive contractual terms. Additionally, civil law systems tend to rely more on statutory law rather than judicial interpretation. This difference in approach can lead to varying levels of complexity and cost in drafting contracts, as well as differences in the adversarial nature of resolving contract disputes. International business operating in Indonesia need to be aware of this distinctions to navigate contract law effectively. Next slide.
Okay, so next, since we've talked about the major kind of laws and also the kind of economy that is applied in a lot of the countries in the world, now let's talk about the legal systems about when it comes to international business and that might harm a business control over their own property. So let's talk about the property rights first. We're going to talk about the corruption of it and also an act that the US is having to prevent it. So let's start with private action. So private action just refers to any kind of theft, piracy, blackmail, and the like by private individuals or also by groups. So although theft occurs in all countries, a weak legal system allows a much higher level of criminal action. So let's just take a blackmail against a government body, for example. I would argue that uh, when a politician in the European Union is getting a blackmail, the case would be handled much more seriously and much in a much more faster manner compared to maybe in other countries in where the legal system is more lacking and less strict. Um, and then we are also going to talk about the public action and corruption. So property rights can be done, property rights when it is corrupted, it can be done by two ways. So private action is by personal or individuals or by groups. So it can be a group such as a mafia in Italy or a group of yakuza in Japan. But when it comes to public action and also corruption, it occurs when public officials extort income, resources, or the property itself from the property holders. Let's stop here for a second and just discuss what property refers to here. So property refers to any sort of resources owned by a company or by an individual that is written in their name. However, it can be extorted by someone else. That is what we call a private action or public action here. So, yeah, this is done by public officials. In a lot of countries, and unfortunately, that includes Indonesia, this kind of practice is still pretty much prevalent even if they are not explicitly showing that they are extorting income or extra resources for their own benefit, they show it in little ways such as trying to obstruct a procedure or something. For example, a lot of movies, when they want to, a lot of movies, Hollywood movies, when they want to make a setting or a story that is based on in Bali, for example, a lot of them would just prefer to shoot in Thailand instead because of the bureaucracy that is much more lax and also easier for them to control. And also, there is no smaller level government trying to extort extra benefits from these Hollywood companies. So that is very unfortunate because we are losing a source of income there, but I think we're hoping that the government will be able to solve that. So this can be done again, what I said, through legal mechanisms, because technically these procedures are legal, and yet they are kind of not necessary, and they can also be done by through illegal means such as corruption, gratification, and also gifts, small gifts for gratification, and so on. In Indonesia, sadly, this is very much prevalent. There's still this term called uang pelicin, or to just some money to ease the procedures of every kind of business. And yeah, it is something that needs to be controlled. In the U.S., they have this act called Foreign Corrupt Practices Act,
which makes it illegal to bribe a foreign government official to obtain or maintain business over which that foreign official has authority, and requires all publicly traded companies to keep detailed records that would reveal whether a violation of the act has occurred. So they have to basically self report themselves when it comes to these things, because again, the government can't do everything by themselves. It was done in the 1970s. Um, and a more recent example of how it is violated would be when, give me a second, when the company 3M, which is very famous, they had to agree to pay for more than $6.5 million to resolve a charge that it violates the books and also the records and internal controls provision of the FCPA here, because the employees of their subsidiary in China, they wrote that they're attending overseas conferences, educational events, and healthcare facility visits, and so on. When in reality they are actually um, doing overseas travel, sightseeing, entertainment on behalf of the company, so to speak. So yeah, this kind of corrupt practices is something that such act is protecting against. Right, so next is, okay, here we have some terms to learn for the next part. First, we have intellectual property or IP. It is property that is the product of intellectual activity, for example, a new drug made by a specific private company. Second one is patent, which grants the inventor of a new product or process exclusive rights for a defined period to the manufacturer, use, or sale of that invention. An example I have here is a patent for the post-it note. Yeah, so it was patented in 1993, and it's still used until now. So the patent is held by this inventor called Arthur Fry. Right, and then next is copyright. I'm sure we all know about this one. It's the exclusive legal rights to publish and disperse their work as they see fit. That is why right now applications or platforms such as Netflix and Disney Plus, they are competing against each other to gain as many subscribers as possible. And one thing that makes it possible for them to even um, compete is the copyright. So Disney can have full rights to have their movies only in Disney Plus, or they can share some to MGM or maybe to Netflix and so on. It's the right for them. Next is trademarks. So it's designs and names officially registered by which merchants or manufacturers designate and differentiate their products. An example of a case here would be the brand New Balance. The brand New Balance has this had the star logo, and they sued a small business company, a small activewear business company, a YouTuber actually, a YouTuber called the Fitness Marshall. They had this star logo as well that looks somewhat similar to the New Balance, and they had to change their logo because New Balance sued them, something like that. All right, so when let's just talk about a case. So when a business is facing IP violations, such as Microsoft here, what can they do, and how can they avoid getting their products pirated in the first place? So when it comes to this kind of thing, they can have various options. So they can lobby the governments for stronger international agreements, such as the TRIPS or TRIPS agreement, which requires minimum IP protection standards. Or additionally, they can also file lawsuits against the infringers, such as Starbucks suing a Chinese copycat. Here, or they can also avoid high risk markets with weak IP laws, so they can just avoid a country entirely, or they can also be vigilant against pirated products entering the home or other markets. For example, in the book, we have an example of Microsoft. They had to track down pirated software produced illegally in Thailand. So it was not just distribution, but it was produced illegally and it was sold globally. And so they had to track it and make sure that it doesn't spread in the home country, US. So by understanding these options, they can either, lobby the government, since a lot of these businesses are huge, uh, or they can just avoid the market entirely. They can navigate the complexities of protecting their IP internationally. So yeah, that is something that can be done. Now, let's talk about product safety and product liability. So, product safety laws set a certain safety standard to which a product must adhere. A product liability, however, involves holding a firm and its officers responsible when a product causes injury, death, or damage. So let's talk about the safety laws first. Here I have an example of Fanta. So the one on the left is the one sold in the US, and the one on the right is the one sold in the European Union. You might notice a difference there. The one in the US is much more colorful, and the one in the on the right is actually made of actual orange juice and not just natural flavor. As you can see there, they have natural flavor. This one has orange juice because they have stricter regulations on certain ingredients. So the coloring here, yellow 6 and red 40, is actually not illegal in the EU, but it is like frowned upon, and businesses rather skip it entirely. So yeah, these dyes are less common in Europe because in order to use them, the product must include a warning on the label about its potential harmful effects on the attention and focus of children. So that to business, it might seem oh, this is not good for my business. It might look like my product is actually very harmful. So they rather just skip it entirely. So yeah, when laws are tougher in a firm's home country than in a foreign country, should a firm follow the local standards or adhere to the home country standards? Um, that is something that is answered here. So sometimes a company would just rather follow one in the foreign country just to make it easier for them. Right, so here we have the conclusion of this chapter. So this chapter highlights how the political, economic, and legal systems of countries significantly impact international businesses. This includes the difference between collectivism and individualism, different kinds of economy, and different legal regulations. So, by understanding these fundamental differences, we as management professionals, we need to, because it's important for us to be able to assess potential benefits, costs, and also risks when doing businesses internationally. So, yeah, so basically, as I've said before, property rights means variation in protection that affects business operations. Product regulations mean safety and liability laws that differ across countries. And contract laws means the legal framework for agreements that can vary significantly between countries. Um, right. So that is all from our group. We would like to say thank you for this opportunity to Sir Clemens and our friends, and thank you.